Good day everyone. So for this video I will be discussing about the rule on the writ of amparo. So let's proceed. So section 1, petition. The petition for a writ of amparo is a remedy available to any person whose right to life, liberty, and security is violated or threatened with violation by an unlawful act or omission of a public official or employee or of a private individual or entity. The writ shall cover extra-legal killings and enforce disappearance or threats thereof. Section 2. Who may file? The petition may be filed by the aggrieved party or by any qualified person or entity in the following order. Any member of the immediate family, namely the spouse, children, and parents of the aggrieved party, any ascendant or descendant or collateral relative of the aggrieved party within the fourth civil degree of consanguinity or affinity in default of those mentioned in the preceding paragraph, or any concerned citizen, organization, association, or institution, if there is known each or known member of the immediate family or relative of the aggrieved party. The filing of a petition by the aggrieved party suspends the right of all other authorized parties to file petitions. Likewise, the filing of the petition by an authorized party on behalf of the aggrieved party suspends the right of all others observing the order established herein. Section 3. Where to file. The petition may be filed on any day and at any time with the regional trial court of the place where the threat, act, or omission was committed or any of its elements occurred, or with the Sandigan Bayan, the Court of Appeals, the Supreme Court, or any justice of such courts. The writ shall be enforceable anywhere in the Philippines. When issued by a regional trial court or any judge thereof, the writ shall be returnable before such court or judge. When issued by the Sandigan Bayan or the Court of Appeals or any of their justice, it may be returnable before such a court or any justice thereof, or to any regional trial court of the place where the threat, act, or omission was committed or any of its elements occurred. When issued by the Supreme Court or any of its justices, it may be returnable before such court or any justice thereof, or before the Sandigan Bayan or the Court of Appeals or any of their justices, or to any regional trial court of the place where the threat, act, or omission was committed or any of its elements occurred. Next, Section 4. No docket fees. The petitioner shall be exempted from the payment of the docket and other lawful fees when filing the petition. The court, justice, or judge shall docket the petition and act upon it immediately. Next is Section 5. Contents of petition. The petition shall be signed and verified and shall allege the following: the personal circumstances of the petitioner, the name and personal circumstances of the respondent responsible for the threat, act, or omission, or if the name is unknown or uncertain, the respondent may be described by an assumed affiliation. The right to life, liberty, and security of the aggrieved party violated or threatened with violation by an unlawful act or omission of the respondent, and how such threat or violation is committed, with the attendant circumstances detailed in supporting affidavits. The investigation conducted, if any, specifying the names, personal circumstances, and addresses of the investigating authority or individuals, as well as the manner and conduct of the investigation, together with any report. The actions and resources taken by the petitioner to determine the fate or whereabouts of the aggrieved party and the identity of the person responsible for the threat, act or omission, and the relief prayed for. The petition may include a general prayer for other just and equitable reliefs. Section 6. Issuance of the writ. Upon the filing of the petition, the court justice or judge shall immediately order the issuance of the writ if on its face it ought to issue. The clerk of court shall issue the writ under the seal of the court, or in case of urgent necessity, the justice or the judge may issue the writ under his or her own hand, and may deputize any officer or person to serve it. The writ shall also set the date and time for summary hearing of the petition, which shall not be later than 7 days from the date of its issuance. Next is Section 7. The penalty for refusing to issue or serve the writ. A clerk of court refuses to issue the writ after its allowances, or a deputized person who refuses to serve the same, shall be punished by the court, justice, or judge for contempt without prejudices to other disciplinary actions. Next is Section 8. How the writ is served. The writ shall be served upon the respondent by a judicial officer or by a person deputized by the court, justice, or judge, who shall retain a copy on which to make a return of service. In case the writ cannot be served personally on the respondent, the rules on substituted service shall apply. Section 9. Return contents. Within 72 hours after service of the writ, the respondent shall file a verified written return together with supporting affidavits, which shall, among other things, contain the following: the lawful defenses to show that the respondent did not violate or threaten with violence the right to life, liberty, and security of the aggrieved party through any act or omission. The steps or actions taken by the respondent to determine the fate or whereabouts of the aggrieved party, and the person or persons responsible for the threat, act, or omission. All relevant information in the possession of the respondent pertaining to the threat, act, or omission against the aggrieved party, and if the respondent is a public official or employee, the return shall further state the actions that have been or will still be taken to verify the identity of the aggrieved party. Number 2, to recover and preserve evidence related to the death or disappearance of the person identified in the petition, which may aid in the prosecution of the person or persons responsible, to identify witnesses and obtain statements from the concerning the death or disappearance. Number 4, to determine the cause, manner, location, and time of death or disappearance, as well as any pattern or practice that may have brought about the death or disappearance. To identify and apprehend the person or persons involved in the death or disappearance, and number 6, to bring the suspected offenders before a competent court. The return shall also state other matters relevant to the investigation, its resolution, and the prosecution of the case. A general denial of the allegations in the petition shall not be allowed. Section 10. Defenses not pleaded deemed waived. All defenses shall be raised in the return, otherwise they shall be deemed waived. Section 11. Prohibited pleadings and motions. The following pleadings and motions are prohibited: motion to dismiss, motion for extension of time to file return opposition, affidavit, position, paper, and other pleadings, the dilatory motion for postponement, motion for a bill of particulars, counterclaim or cross-claim, third-party complaint. Reply, motion to declare respondent in default, intervention, memorandum, motion for reconsideration of interlocutory orders or interim relief orders, and petition for certiorari mandamus or prohibition against any interlocutory order. Next is Section 12, Effect of Failure to File Return. In case the respondent fails to file a return, the court, justice, or judge shall proceed to hear the petition ex parte. Next is Section 13, Summary Hearing. The hearing on the petition shall be summary. However, the court, justice, or judge may call for a preliminary conference to simplify the issues and determine the possibility of obtaining stipulations and admissions from the parties. The hearing shall be from day to day until completed and given the same priority as petitions for habeas corpus. Next is Section 14, Interim Reliefs. Upon filing of the petition or at any time before final judgment, the court, justice, or judge may grant any of the following reliefs. A. Temporary protection order. The court, justice, or judge, upon motion or motu proprio, may order that the petitioner or the aggravated party and any member of the immediate family be protected in a government agency or by an accredited person or private institution capable of keeping and securing their safety. If the petitioner is an organization, association, or institution referred to in Section 3C of this rule, the protection may be extended to the officers involved. Inspection order. The court, justice, or judge, upon verified motion and after due hearing, may order any person in possession or control of a designated land or other property to permit entry for the purpose of inspecting, measuring, surveying, or photographing the property or any relevant object or portion therein. Next is production order. The court, justice, or judge, upon verified motion and after due hearing, may order any person in possession, custody, or control of any designated documents, papers, books, accounts, letters, photographs, objects, or tangible things, or objects in digitized or electronic form, which constitute or contain evidence relevant to the petition or the return, to produce and permit their inspection, copying, or photographing by or on behalf of the movant. Next is D. Witness Protection Order. The court, justice, or judge, upon motion or motu proprio, may refer the witnesses to the Department of Justice for admission to the Witness Protection, Security, and Benefit Program. Pursuant to the Republic Act No. 6981, the court, justice, or judge may also refer the witnesses to other government agencies or other accredited persons or provided the court, justice, or judge may also refer to the witness to other government agencies or to accredited persons or private institutions capable of keeping and securing their safety. Section 15. Availability of interim reliefs to respondent. Upon verified motion of the respondent and after due hearing, the court, justice or judge may issue an inspection order or production order under paragraph B and C of the preceding section. A motion for inspection order under this section shall be supported by affidavits or testimonies of witnesses having personal knowledge of the defenses of the respondent. Next is section 16, contempt. The court justice or judge may order the respondent who refuses to make a return or who makes a false return, or any person who otherwise disobeys or resists a lawful process or order of the court to be punished for contempt. The contemnor may be imprisoned or impose a fine. Next is section 17, burden of proof and standard of diligence required. The parties shall establish their claims by substantial evidence. The respondent, who is private individual or entity, must prove that ordinary diligence as required by applicable laws, rules, and regulations was observed in the performance of duty. The respondent, who is public official or employee, must prove that extraordinary diligence as required by applicable laws, rules, and regulations was observed in the performance of duty. The third is the respondent, public official or employee, cannot invoke the presumption that official duty has been regularly performed to evade responsibility or liability. Section 18. Judgment. The court shall render judgment within 10 days from the time petition is submitted for decision. If the allegations in the petition are proven by substantial evidence, the court shall grant the privilege of the writ and such reliefs as may be proper and appropriate. Otherwise, the privilege shall be denied. Section 19. Appeal. Any party may appeal from the final judgment or order to the Supreme Court under Rule 45. The appeal may raise questions of fact or law or both. The period of appeal shall be 5 working days from the date of notice of the adverse judgment. The appeal shall be given the same priority as in habeas corpus cases. Next is section 20, archiving and revival of cases. The court shall not dismiss the petition, but shall archive it, if upon its determination it cannot proceed for a valid cause such as the failure of petition or witnesses to appear due to threats on their lives. A periodic review of the archived cases shall be made by the amparo court that shall motu proprio or upon motion by any party order their revival when ready for further proceedings. The petition shall be dismissed with prejudice upon failure to prosecute the case after the lapse of 2 years from notice to the petitioner of the order archiving the case. The clerks of court shall submit to the office of the court administrator a consolidated list of archived cases under this rule not later than the first week of January of every year. Section 21. Institution of separate actions. This rule shall not preclude the filing of separate criminal, civil, or administrative actions. Section 22. Affection of filing of a criminal action. When a criminal action has been commenced, no separate petition for the writ shall be filed. The reliefs under the writ shall be available by motion in the criminal case. The procedure under this rule shall govern the disposition of the reliefs available under the writ of amparo. Section 23. Consolidation. When a criminal action is filed subsequent to the filing of a petition for the writ, the latter shall be consolidated with the criminal action. When a criminal action and separate civil actions are filed subsequent to the petition for a writ of amparo, the latter shall be consolidated with the criminal action. After consolidation, the procedure under this rule shall continue to apply to this or to the disposition of the relief in the position. Section 24. Substantive rights. This rule shall not diminish, increase, or modify substantive rights recognized and protected by the Constitution. Section 25. Suppletory application of the rules of court. The rules of court shall apply suppletorily insofar as it is not consistent with this rule. Section 26. Applicability to pending cases. This rule shall govern cases involving extra-legal killings and enforced disappearance or threats thereof pending in the trial and appellate courts. Section 27. Effectivity. This rule shall take effect on October 24, 2007 following its publication the 3-in-3 newspaper of general circulation. So that's all for this last video. So in my discussion, so we have the role of the role of amparo, which is have 28 sections. 27 sections. And thank you for listening for this video, and I am very grateful for reporting, and thank you and God bless.